All right, everybody, I appreciate your time coming in here. We're ready to get started. So today we have a presentation. First, I should introduce myself. I'm Dana Collins. I'm the Chief Legal Officer for Drawkin International, and in my spare time, I'm also an ACC board member and officer for our Dallas chapter. And I'd like to introduce our two guest speakers today from Norton Rose Fulbright. I wanted to first show and express our appreciation for Norton Rose Fulbright's very long and continued sponsorship at ACC. It means a lot to us here at Symposium or Golf Spa. You saw some of the slides during the break of our registration for our Golf Spa. And I was just mentioning that we were the only chapter in the country that actually kept our annual meeting have an in-person option last year and kept it safe. So wanted to plug that for that coming up this fall. So I just want to introduce our speakers real fast. I've got an introduction here. You get the bios that you can get online, but who wants to necessarily do that? We have our two guest speakers here, and I'll just mention one quick fact about each that I know here. So first we have Will Doherty with Norton Rose Fulbright. He is the head of the U.S. Cybersecurity practice group, and for the U.S. And then our second guest really wanted to make sure that I made sure that's clear that he's for the U.S. and global is Will Swalina. I practice that and I still mess it up, but I appreciate it. Appreciate both them being here. I did notice that Chris is joining us all the way from D.C. today, so appreciate it. You making the trip down here, and hopefully you're going to get some good barbecue before you leave. And Will, I just went through your resume and noticed you were at GameStop, and so hopefully you held on to some of that stock and then unloaded it during the game stonk. Yeah. Well, without further ado, I will let Will and Chris talk to you about cybersecurity. Thank you.
Thank you, and thanks everyone for having us. There we go. So we'll just start off really just to kind of help explain, why general counsels we're seeing are having an increasingly pronounced role in managing cybersecurity risk, and particularly over the past 2 years, that the prevalence of general counsel getting into areas of managing cybersecurity risk has really exploded, and it's for good reasons, and it's reflected too. If you look at the ACC's annual report last year, which surveyed the chief legal officers and asked them to rank from 1 to 10 the level importance of issues that are most important to the business, cybersecurity was rated the highest level importance, above litigation, above tax, above a lot of different issues. And the same was the case last year. Cybersecurity was the #1 most important risk to the business. And it just increased. Last year it was at a 7.7, now it's up to 8.1. And so why is that? And a lot of what we've seen just over the past several years has been some major matters arise, and that really thrust the general counsel into a much more significant role. So many years ago, when we would talk to general counsels and to in-house counsel about cybersecurity, they'd generally take the view that this was an IT issue, right? This isn't really something that we need to be involved with. Well, that has obviously changed, and there's a lot of good reasons for it. Just for one example, Yahoo. In 2014, the Yahoo information security team notified the legal department that they had identified evidence of unauthorized access to several systems containing Yahoo customer information, such as email addresses and hash passwords. The legal department didn't move forward with any sort of investigation, and so it basically died at that point. Then you fast forward to 2016, when Yahoo was being acquired by Verizon, and during the due diligence process, the fact that this incident occurred came to light. And as a result of the due diligence, they actually decided that they needed to notify the public, and so they issued a press release, and there was a huge number of class actions that were ultimately filed. Plus, they had to write down the sale price, $350 million, as a result of this incident that wasn't previously disclosed. The board then engaged a formal investigation to find out what happened. And the result of that investigation was that the general counsel resigned without any compensation, because it was determined that the litigation team, the legal team, was made fully aware of sufficient facts for them to know that this required a more in-depth investigation and nothing was done. So despite the fact that this was a cybersecurity incident, that it was ultimately laid at the feet of the general counsel for responsibility. And the SEC ended up bringing a enforcement action, which they had to settle for $35 million. Another good example is in Marriott, Starwood. So in that matter, the Marriott acquired Starwood, but unbeknownst to them at the time, when they acquired them in 2016, they had actually had an incident occur in 2014 in Starwood systems. And only in 2018, when they identified threat actor activity in their environment, did they realize that there was a massive breach that occurred involving hundreds of millions of their guest information. And immediately upon disclosing this, the organizations faced dozens of class actions and regulatory fines, including a $30 million fine from one regulator, the United Kingdom's ICO. And it could have been 130 million, but they were lucky in that GDPR wasn't in effect yet. So again, mergers and acquisitions, due diligence, had the legal team done sufficient due diligence to be able to identify that this breach already existed in Starwood, they acquired this breach. So, and then you fast forward to the Colonial Pipeline incident, which many of you probably heard on the news last year, when one of the major pipelines to the eastern seaboard for petroleum was hit with a ransomware attack that ultimately led to the shutdown of that pipeline for several days. And you probably saw many of the videos in the news of people filling up hot tubs with gas and plastic bags. It was not a good situation, and cost the company hundreds of millions of dollars, and it ultimately resulted in their CEO having to testify before Congress. So these issues are not just IT issues. They are enterprise-wide risk issues.
I'm going to go back actually and to what you said about cyber security being a growing issue for companies, or a top issue for companies. 20 years ago, when I started doing cybersecurity work, law firms didn't have practices. I was in-house at the time, and we had a large cyber attack that we had to respond to, and I had to hire a bunch of law firms. And wound up hiring 10 different law firms to handle all the different aspects of what occurred, and there weren't cybersecurity lawyers in law firms at the time. Now they're everywhere, and everybody says they have a cyber practice. Our team globally, we have 100 lawyers that do just privacy and cybersecurity. So and we can't hire fast enough, and we can't find lawyers with cybersecurity experience. So that's what's happening in the field. Also in-house, our clients are, how many people here have cyber in their purview?
Oh, wow.
And how many people think they probably ought to have cyber in their purview? Yeah, I mean, a lot of our clients don't have, more and more over the last couple of years even, companies are naming specific cybersecurity lawyers devoted to cybersecurity. Big difference between cybersecurity and privacy. There's some overlap, to be sure. But if you don't know what the difference between cyber and privacy is, then you're probably a privacy lawyer. There is a big difference between the two areas. What's happening in the landscape has been pretty crazy over the last 3 years. Now that you have, you all see, of course, we see in the headlines every day, something about cybersecurity, something about an attack. When you have the president talking about cybersecurity, then people start paying attention a lot more. What's happening? Well, ransomware, obviously, that's a big one. Everybody knows about ransomware. That's been happening quite a bit lately. We're also seeing the ransomware field change. So ransomware as a service is now a thing. So now the bad guys are selling malware to affiliates. Those affiliates use the ransomware. The developers of the malware get a cut. The developers of the malware also have run office hours with IT support, phone lines. They also manage websites where they post stolen data. I mean, they operate like real corporations, and they're making, of course, a ton of money. Oh, by the way, we should have said, stop us, anybody raise their hand at any point, because we want to make sure we hit stuff that you guys are thinking about or have questions about, so please stop us as we go along. The other thing that we're seeing develop, and this is probably in the last year and a half, 2 years perhaps, is maybe a little less, is pure data theft, pure data extortion. So instead of the ransomware, they're just getting into your environment, stealing a whole bunch of data, and then extorting you. So we're seeing, too, an unbelievable increase in sophistication. And it's a bit of an arms race that is occurring, and it's easier for the bad guys. It's much harder for the good guys to keep up, because you only need one sort of failure to get into the environment. And getting into the environment isn't really hard at all at any company. The trick is how quickly can you all detect and respond. And what I can tell you is, if lawyers are sitting back and you're sitting there thinking, well, we've got good IS teams, we've got good IT teams, we're covered, we spend a lot of money, then you're not really thinking about the job that legal has overseeing information security well enough. And the problem that we see so all we do for a living is get called in when there's been a disaster and we have to respond to it. So we see all of the failures that occur, and we do root cause analyses of what occurred, and we figure out what went wrong. And there's two things I want to sort of set the stage with, and tell you what we see happening. By the way, we've represented some of the largest corporations, Fortune companies that spend a lot of money on cyber, but yet they're making headlines. So why is that? Well, there's sort of two things. I mentioned one, which is sort of a silo thing. So what I wanted to talk about, and this is not even on the slide, but what I wanted to tell you all about is, after all these cases that we've dealt with, what's really happening? There's sort of two things. There's a macro issue and a micro issue. The macro issue is where the lawyers can jump in more readily. It's more comfortable for lawyers to jump in, and that's governance and risk management. That's sort of the macro issue that's occurring at these companies. You have information security operating as a silo. Information security might report to IT directly without oversight. That's always a problem. You said people view this maybe as an IT problem. It is actually an IT problem, but in a different way than what you meant. Right. So what you were referring to is that people think this is not for the lawyers. Exactly. The problem is, it is an IT problem, and that's why we have the security issues that we have. And if you don't have good governance, risk management, if lawyers aren't involved in what is happening in the security program, if lawyers don't know what the security stack is, and they know how the security operations center runs at the company, don't know whether it's a self-sustained or hybrid or fully outsourced, and you don't know these things, that's the problem. If you're not paying attention to assessments, pen tests, all of the stuff that's happening before there's an incident, that's a problem. If you're not involved in incidents, not just the major crisis, we think we have data stolen, but if you aren't involved in incidents early in the process, then that's a problem. So the macro issue is the governance, oversight, risk management issue. What's the micro problem? The micro problem is that we have people, tools, technology. Every single company in this room has that to some degree or another. You have stuff in-house, you have stuff outsourced. But how are you detecting and stopping these incidents? You actually have to have people with their eyes on the computer screen. There are people watching millions of events that are occurring a day. Yes, we have artificial intelligence. Artificial intelligence is not a solution. Despite what any vendor tells you, artificial intelligence is not a solution. You have to have people do stuff. And people fail to do stuff over and over and over. Every single case we've had, major cases that have cost companies well north of $100 million, have had significant failures, not one, not two, but dozens of opportunities to stop the intruder in their tracks before they accomplish their mission. So why? What's happening? Well, that's the people process. point. And that's the in the weeds point, micro point. There's a role for lawyers there too. I can tell you that we try to help our clients solve that by getting plugged into their SOC alerting processes. So our teams get alerts just like the information security professionals on the ground, because it is a team sport. It's a risk management sport. And so if lawyers aren't thinking about those issues, the big top oversight issue, governance issue, and the in the weeds issue and what's happening, there's a lot to pull apart in both of those things I just said. But when I was in-house and if I was in-house, that's how I'd be thinking about things.
Yeah, and a lot of times just having that being plugged in from a lawyer standpoint, you see a lot of the symptoms. Even if it's not a major incident, you see a lot of the symptoms that you can address early on before you get to a big incident, because you're giving feedback to the information security team. You're helping them manage that risk. And if you're not plugged in, then most of the time the legal team's not finding about these incidents until well after an incident and investigation's begun, and that's just too late. And so really it's important to get
We'll go to this next slide. So in addition to ransomware, we're also seeing a real increase in nation-state intrusions. So it's not just the news, it's not just seeing the stuff about the geopolitical situation we're dealing with in the Ukraine, which is terrible, but we are seeing a significant increase in nation-state intrusions, primarily from Russia, China, North Korea. Iran is stepping up their game. These actors, the challenge here is, these actors are really, really good. They're very, very good at getting into your environment and laying low and accomplishing their mission without anybody realizing what they're doing. So this is a different level of challenge than the ransomware guys that we were talking about. There's sort of levels of actors. The first set we were talking about is the one that we've been seeing tons on the news, and that's the ransomware guys, data theft guys, extortion guys. These are the financially motivated, organized criminal gangs. Those guys can and should be stopped. They're not operating at the same level as the nation states, with one caveat, which makes it a little bit complicated, is that there is starting to be a lot more connection between the two, and probably payments going to governments from some of the tolerated criminal gangs. The other thing that makes it really difficult for companies is it's not just you, it's your vendors. We're seeing a lot of supply chain attacks. We have a lot of financial institution clients. Their biggest risk, they spend over $1 billion. Some of our clients spend over $1 billion a year on cybersecurity, but they have huge risks. Why? Because of vendors and because of third-party software providers that they rely on and are embedded in their products and services. So supply chain attacks have also made a lot of news, Log4j, SolarWinds, et cetera. That is another thing that is happening that makes this space quite challenging.
Yeah, and at the same time, the threat landscape has been evolving, being much more challenging. So has the legal landscape. For many, many years, for the past 20 years, we primarily in the U.S. had really a patchwork quilt of state and federal laws. And the state laws were really basic. They're just these breach notification laws where any personally identifiable information is compromised. Organizations have an obligation to notify those individuals and certain regulators. We're now seeing not only the expansion of what is a notifiable incident and whether an attorney general needs to be notified. It was just last year that Texas actually implemented a notification requirement to the Texas Attorney General. That didn't even exist for the past 20 years. So they are trying to be more proactive in the space, and they're getting much better in terms of the questions they ask. For many years, they just did not have the in-house technical expertise to be able to, once you disclose an incident, to really understand what the organization was doing wrong. They even outsourced third-party vendors who have that infotech experience to be able to look at these notices. They'll ask some questions, and if you don't give answers that show that you were adequately prepared, then they will start opening more formal investigations. The other thing that they're doing is, for only a handful of states, for the longest time, had a requirement that organizations maintain some level of reasonable security, without that really being defined. We've seen more states now starting to adopt more prescriptive requirements, like Massachusetts, that specifically say you need to have a written information security program that meets all of these requirements. None of the information security teams are looking at whether or not their program is meeting any of these requirements. So legal's got to take a role in saying, hey, show us your program. Is it meeting all the requirements that we operate in? And similar, we have the FTC was traditionally the other federal regulator that brought enforcement actions. And they have jurisdiction under Section 5 for unfair and deceptive trade practice. There are no specific requirements under the statute for cybersecurity. Basically, they've interpreted a reasonable security standard into the Unfair Trade Practices Act. And the only sort of guidance that we have are through the enforcement actions. So they haven't really been active in this space. The new commissioner, Lena Powers, who's the new commissioner, was just at the IAPP conference in DC, one of her first public speaking, and they're actively looking to put forth some prescriptive cybersecurity requirements if Congress isn't going to do anything, because they haven't done anything yet. So we're expecting to see more activity out of the FTC. And then we've always had this historical federal patchwork based upon the industry. We have HIPAA and high tech that's applicable to healthcare entities. One thing, though, that everybody should know, even if you're not in healthcare, to the extent you have a self-insured health plan for your organization, that plan is a covered entity, and you may not realize it, but you may be subject to HIPAA. And Gramm-Leach-Bliley Act, again, these laws have been around for almost 20 years, so there hasn't been a lot of movement. But what we are seeing is the regulators that are charged with enforcing those laws. So GLB is the SEC for broker-dealers, investment advisors. You have the OCC, FDIC, and for banks. They're all promulgating new regulations. OCC just released a 72-hour notification requirement, as well as very prescriptive cybersecurity requirements. So this is really evolving very quickly, as well as the privacy laws. But let me go back to the next one. Well, things really changed after the Colonial Pipeline incident, when we saw an impact on our critical infrastructure. And as Chris was mentioning, when President Biden started talking about cybersecurity as being a national threat, we saw more activity in this space since then. It has started off with the pipelines for obvious reasons. Colonial Pipeline was a pipeline. And they have issued very, very prescriptive cybersecurity requirements, including notification to the Cybersecurity Infrastructure Security Association or agency within 12 hours after an incident occurs. If legal is not involved in an incident from the moment that it gets detected, there's no way organizations are going to be able to meet that 12-hour requirement. And you certainly don't want to leave it up to the analysts that are monitoring your environment to make the assessment of whether the organization has a reporting obligation. Similarly, they've imposed these significant cybersecurity requirements on organizations and have to attest and certify under penalty of perjury that they have met all of these requirements. And that's expanding. So the TSA issued similar requirements for reporting to the aviation industry. So airline operators are now subject to this. And more recently, just last month, the Cyber Incident Reporting for Critical Infrastructure Act was passed. And this basically directs CISA to promulgate rules that are going to be designed for critical infrastructure entities. And there's 16 critical infrastructure sectors, and it covers just about every type of industry that you can think of, from obviously energy to transportation to chemical to technology, communications. And they're going to be requiring reporting requirements within 72 hours after you reasonably identify an incident. And they're going to require that those companies notify CISA of a ransom payment that's made. So seeing a lot of movement. And most of you probably also seen just last month that the SEC is finally proposing rules and requirements for reporting material cybersecurity incidents on a Form 8K within 4 business days after the organization makes a determination that a material cybersecurity incident occurs. The reality is that the SEC has already brought enforcement actions for companies failing to provide notifications of a material incident on a Form 8K. So they're not adopting any new rules. They're basically just interpreting the rules that they have and making them more formalized. They're also, interestingly, proposing to require in periodic disclosures that organizations disclose policies and procedures to identify and manage cybersecurity risk, management's role in implementing those, as well as the level of expertise of directors on the board of directors and how they oversee those risks. as well as if you have an incident, then you have to provide updates on those material incidents through your periodic reporting. So this is a big deal that the SEC has finally come forth and said, you know what, cybersecurity is a material event and an aspect of an organization's business to investors. And so we're going to start requiring these things. I'll let you give it this one.
Yeah, sure. I mean, so this, the evolution of the general counsel's role. So, again, this is one of the biggest, if not biggest risk areas there is. The survey you mentioned with legal folk identifying it, but it's also identified by boards and C-suite as in the top, 1, 2, or 3 risks of an organization. So if that's the case, then shouldn't general counsel and the legal department be heavily involved in the space? And the answer is absolutely yes. The problem with this, often is with clients we have is they think that, okay, well, again, we've got IS teams and they think they've got it covered and we're good, and we can tell you that they're not good, and they don't have it covered, and they need lawyers' help. And part of the mission is helping them understand what the lawyer's role is in this space and how lawyers can help improve the overall risk posture of an entity. We've had cases where, and we're going to go through each one of these sections. I think go back one. The cybersecurity compliance, board oversight, integrating into risk management, information governance, and third-party risk management. We'll hit each one of these topics and give you a little color about how the legal department can be embedded. One just sort of thing I want to add is, we're again, when we respond to these major incidents and we're in front of the board, we get asked a lot of hard questions, and the boards will say, well, hang on a minute, I've had this executive management team report to us every quarter for the last couple years, and they've reported to us about the maturity of our cybersecurity program, and I see these slides and they look pretty darn good, and we've got all these colors and charts and things that say we're good, and meanwhile, a threat actor just took us to our knees, almost collapsed the company, and stole 6 terabytes of data. How does this happen? And that's what we're talking about here, right? And we're not going to be able to tell you everything and get into all of it, but one of the main reasons is that you don't have lawyers in a close partnership with the information security people. Example would be CEO. We have to tell him or her that the vulnerability in a web application was compromised, and that's how the threat actor got in. And then the CEO says to us, well, why did that happen? Well, it wasn't patched. Well, who was in charge of that? Well, your IT department is saying that the IS department, and your IS department is saying the IT department, and it wasn't patched. And so, the CEO sits there and scratches their head, and they say, you mean to tell me I understand every single risk in this organization, every single one, and you're telling me that somebody signed off on this risk and said it was okay, and I don't know about it, and it costs us this much money and attention to our brand? And the answer is yes, and that's sort of the point we're trying to make here. Let's go to some. So, what can lawyers do for incident response prep? Well, lawyers need to be involved in incident preparation. That means helping with incident response plans, helping develop exercises. Tabletop exercises and drilling and exercising, making sure that the plans actually reflect reality on the ground. The hardest part about this area, though, and this is why, all of this stuff that we're talking about takes a lot of time. All of it takes a lot of discussion and interaction with the teams on the ground. But the hard part about this is, how many tabletop exercises have we done? I don't know. It's too many to count. And even with clients that we've done them, that have had major incidents. they're really hard to mimic. A lot of it is sort of, you go through the motions and you sit in a room. And I was in-house counsel. I remember some of these, and you're just like, yeah. And you go through the motions. That's not helpful for anybody. So what we try to focus on is drilling and testing the things that we know are going to likely go wrong. And the way you figure that, though, out first is talking to your information security people about where the gaps are. So we see the same things happen over and over again in every incident. Companies have the same problems. They fall down in the same exact places. So those are the areas that you really want to drill in and test. Anything here you want to add?
Yeah, no, I mean, I think really drilling down, we do tabletop exercises primarily not just to sort of build the muscle memory and educate many of the participants, and oftentimes we'll do one for a lower level incident response team, then the executive team, the CEO, the CFO, the CEO, and then to the board. But the reality is we come into these after knowing the organization's posture and knowing what our objectives are coming out of this. It's usually to make them aware of certain risks within the organization that need to be addressed now. And we highlight those risks for the organization that, hey, right now, you don't have the ability to identify every single one of your assets within this organization. That's one of the first steps that we need to be able to do when we're in an incident response. And so we try to bring that to light. And the IT guys are saying, well, we don't have the tools to do it. Well, that's why we need to be the partner to bring that to the attention of management to get this approved. So that's where we think the biggest, benefit of doing these tabletops is to make management aware of these risks and drive change within the organization.
And everybody has to be honest that participates in these tabletops. That's another thing that lawyers can help. Oh, go back, stay on this slide just for a second. I wanted to mention ransomware. Make sure you have a ransomware specific plan if you don't, and make sure you think about how exactly you're going to do the payment approval. So we've had some congressional investigations that we've had to manage and some significant regulatory investigations about payment issues to bad actors. A lot of scrutiny around how is the decision made, who is it made by, and what were those communications around the decision. So we want to tightly manage, as lawyers, the decision-making process that the company makes with respect to paying a ransom. Obviously, you could have potential criminal penalties and civil penalties if you pay a sanctioned entity, which makes things particularly challenging with existing compliance regimes in Russia, because a lot of the actors come from there. So make sure that you have a preordained plan. Make sure your CEO, make sure the C-suite knows what the plan is, knows what's expected of them, knows what the board's role is. We see a lot of companies get this wrong. They think that the board needs to approve. Well, maybe, but likely not. Most likely the board does not need to approve the payment, because that should be dealt with in delegations of authority. And what I'm suggesting is this needs to be thought of in advance. Everybody needs to know their role. The board should be told too, this is what we're going to do if we're in this situation and we have to pay. This is how we're going to inform you. This is the portion of the board or full board that we're going to talk to, and this is how we're going to document it and make sure that we do it in the right way. That's really important to get to practice now, because everybody, including FIs, are at risk for ransomware attack.
Yeah, and the other thing too to think about when we talk about ransomware playbooks, we're not just talking about what is information security team and what is the legal department doing. Another real important role that legal can play is making sure that the communications department knows exactly what their playbook needs to be, exactly how all those communications, before they start issuing those, go directly through legal, because everything that is said in those public communications and even internal communications are going to be Exhibit A, and that's going to be exactly what that you're going to be criticized on. So legal has a really important role to get involved in those work streams, in the business continuity and disaster recovery work streams, because if your systems are offline and your business is not able to function with the critical systems that they need, then we need to have a plan to be able to mitigate those as quickly as possible, because there are legal risks. And so legal can really play a major role in making sure there's harmony between all these different groups who are going to have a lot of work in one of these scenarios.
The thing I want to talk about in terms of the next topic is board. Well, we already mentioned some stuff about board, but the thing I want to mention, Will, and then let you add something. The thing that I want to mention is Going back to my comment about the board saying, wait a second, we've been seeing a lot of stuff. So it is the lawyer's role to understand, is the board being told a bunch of fluff, or are they being told substance? Lawyers need to know what's being presented to the board. You know every other topic that's being presented to the board, so you need to know what the security stuff is. You need to know what the charts and the numbers and the things actually mean and translate to that your board is being told about the risk posture of the company. And if you don't know, that's on the lawyers for not knowing. And so I think that's really important and something we see missed a lot. In the last year, we've been hired 3 times by 3 publicly traded companies because there's been a thought that what was presented or has been being presented to the board is inadequate and is giving the board a false sense of maturity of the cybersecurity program. This typically has happened, or at least I think in all 3 cases, it happened when a new CISO was brought in to lead the team, and the CISO kind of sits back and looks at what's going on, looks at what's happening in the environment and says, whoa, how is this being conveyed to the board when I'm learning this over here? And I think that happened in all 3 cases, was a new CISO. Our job was to come in and figure out what was really going on. Now, what we did in each one, well, some are still in flight, but what we did in each one of these cases is to really sort of assess whether we thought that, and we didn't go to the boards, of course, and say, oh, well, somebody's been, lying to you or whatever, but rather put forth a more fulsome picture and say, look, we are going to now go forward reporting this way to you on these topics because we want you to see clearer. So that was sort of the messaging we did. You were going to say?
No, I was going to say, but we did look at whether or not they were being provided with the truth, right? And general counsels wanted to know whether they needed to go to the board and say, hey, look, this where we currently are is very different than what you've been told over the past 8 quarters. So it was part of it. But what we had to really do is to come up with a strategy over the next 4 quarters to be able to educate the board and make them better appreciate the risk to the organization on the cybersecurity posture, while at the same time addressing a lot of the major risks that were identified. So we worked very closely with the CISO, the general counsel, on all of those board presentations. And what we were doing, and some of these are just basic too, and how do you actually assign responsibility to the board to oversee the cybersecurity risk. And the reality is there's not a mandatory mechanism of doing that. In some organizations, it's delegated to the full board. In other cases, it's an audit committee, or it's a combination of the 2. Or there's special committees. It varies. But the reality is that, number one, that organizational structure and responsibility needs to be documented in the charters. And 2, you've got to set the stage for these board members to be successful in their oversight. So what we do is we plan out an awareness strategy, an education strategy, by making sure that the organization, the board, is not just hearing from the CISO, right? Because that is just one part of the optics of understanding what risks there are from a cybersecurity perspective. So we've got the CIO. We even have the general counsel speak on some of the areas, like vendor management. And so getting the risk officer in front. So educating the board is really important because you definitely want to avoid the situations that we see all too common after an incident occurred. Boards just being completely surprised that everything that they've been told by everyone within the organization is that things are really good, but the reality is they've gotten metrics and things like that just don't make the board appreciate the real posture of the organization.
So cybersecurity compliance, one of the ways that lawyers can get involved here is, I mentioned this a little bit, but risk assessments, maturity assessments, penetration tests, vulnerability scans. We do a lot of this work under our direction. We engage third parties to do this work. What we can tell you is that this is the roadmap for plaintiffs' lawyers. These are the roadmaps for regulatory investigators who come in after an incident. These are the documents that they will request. They will want to see them, and they will want to know what was done with them. So having lawyers involved in this is really important. It's not that anybody would think that I was saying, but we're not whitewashing. The lawyers aren't whitewashing the situation. You're not trying to cover, and hide the findings. It's actually quite the contrary. We want them to surface, and we want them addressed. Lawyers, what we're really good at, right? Lawyers, I mean, I'm speaking about the group, we're really good at asking questions. We're really good at identifying risk. We're really good at investigating. And that's what needs to happen. And that's what we're saying. We're seeing a lot of companies where there isn't that partnership. And things just sit and don't get done, don't get prioritized, not enough money here, not enough time to do X, Y, Z, and nobody's banging on the table and saying priority, priority, priority. This is a problem for us if we don't focus on it. That's where the lawyers can come in, because lawyers get listened to. I mean, mostly not, but sometimes. And we're good at raising our hands and saying, hey, there's a problem here, and that's part of what we're talking about here in the compliance bucket.
Yeah, and one way we do that is through regulatory assessments. And basically, what the reality is, in most information security groups are doing assessments that are based upon a technical framework that addresses very specific areas from a technical level. But when an incident occurs, regulators are oftentimes asking questions that go well beyond and are very different from the types of questions that are asked during a technical assessment. And the reason it's important to be well prepared for those, particularly during those first few days where the regulators are asking for daily updates, but at the same time they're asking for information requests that really go back to speak to how the organization was prepared. The quicker that you can provide good answers to their information and documentation, the less likely they are to bring an enforcement action, and the more likely they're going to give the organization room to breathe and respond to the incident and focus on the things that matter. And it also helps us identify those gaps, that areas, well, it might not be required from a technical perspective, the organization needs to have, because there's a regulatory expectation that you're doing these things. So that's a really good thing for a legal team to get involved with.
Risk management, well, we've been talking about that a lot, but all of the companies in this room will have cybersecurity frameworks that your teams utilize. The lawyers should know what that is. Which framework do you use? You should know that. Do you know what, is it NIST? Is it the cybersecurity framework? Is it 800-53? 800-171? Is it ISO? What framework do you have, and where are you in the framework and the roadmap for cybersecurity maturity? Lawyers actually need to know that. That's what's going to get, again, asked for, and you need to understand where are the gaps in the company in all of these critical key areas. I'll use another example of the vulnerability management again, because that's something that all companies struggle with, is vulnerability management, patching. Everybody struggles with that. But as lawyers, you should also know that you're making representations all over the place relating to your vulnerability management program. To your insurance carriers, you'll make representations in your policies and procedures that you have patches fixed if they're critical or high at a certain time frame. They're probably not complying with your own policies, more likely than not. The mature companies know this, and they will have a risk management program built aside it, which provides for exceptions and tracking the exceptions. But we have found over and over, even those companies with those more mature processes fall short of what needs to be documented with respect to the risk and the decision making. So go back to the point that I made earlier about the CEO saying, wait a minute, I know every risk and I don't know this. Well, because often we'll find that it's either not documented, the risk isn't documented well, or it's the fox guarding the hen house. You've got somebody, or the business owner or head of IT signing off on the risk. Well, what sort of oversight is that? Because of course, the person who's in charge with keeping the business running and making money is going to sign off on the risk, because that's their job. They're not thinking about it in terms of how this could go terribly badly. That's not how they're looking at it. So getting lawyers involved in understanding how all these things are working in the enterprise, it can help you be a better organization and safer organization.
Yeah, and most of our organizations that do have they are sophisticated enough in their cybersecurity maturity to have their program integrated into enterprise risk management. Those lawyers, the general counsel, the deputy general counsel, are on a risk committee. They're looking at those same risks too with other department heads that sit on that risk committee, and looking through those exceptions to see whether they should be signed off, raising them to the CEO if this is something that they feel the committee shouldn't be signing off this without the CEO. So that's the maturity level you want to get to, right? And you've got a multidisciplinary team that definitely needs to include legal on that.
Well, the next topic is the one that makes everybody sigh. 5 minutes left? Okay, so this is really important, though. Everybody has data all over the place, and that's a fact. Getting lawyers, though, involved in information governance is critical. Here's what we can tell you, because I know we have short time. What we can tell you is in every major case we've had that have cost $1 gazillion for these companies, it's because the threat actors stole a whole bunch of data that shouldn't have been there. They will go after data that is low-hanging fruit. They will go after data typically not in databases unless they're nation state. Typically, they go for file shares. File shares have gobs and gobs of data that shouldn't be there. I can't think of a case that we have had where the sensitive personal information of every employee wasn't taken. So this happens over and over.
Even though they have like an outsourced or a singular structured database, but it's the data management was so poor that those spreadsheets that contain every employees are still being left on.
And see, that's the point. And maybe we just end here and ask if there are any questions. The point you just raised is that, we ask questions, say, oh, we're with Workday or we're over here or whatever, we got this vendor. Again, we're good. You're not good. We're telling you. You are not good. There is going to be, it's peeling the layers and getting in. Don't just take the yes or the this or we got the contract. Everybody says we have security and privacy clauses in their contracts. Every contract we pull when we need it, we need to go after a third party, the contract provisions suck. So I can tell you that there is work to do here. You have to pull back the layers. Maybe we should stop and see if there are questions.
Yeah, just one other thing. I mean, information governance underlines all of the good cybersecurity. You cannot have good cybersecurity if you don't have good information governance. And if you look at those 4 things, e-discovery, you look at privacy, compliance, record management, the legal departments play a huge role in all of those things. And really, when it comes to like your retention policies, it's not just about having those policies, it's about the ability to enforce those and make sure that employees are not creating and adding data to not deleting the data. So can't emphasize enough how important legal has a role in information governance. And we'll just end with this last slide. With third-party management, just because third-party vendor risk management is critical. You've got to be able to legal needs to be involved in that program where you're identifying the vendors who create the most risk to the organization. You're making sure your contractual provisions are mitigating or eliminating those risks, and that we're continually auditing those because they're huge.
Well, let's flag one for you. So again, for your SOC, for your Security Operations Center, you have third parties doing monitoring detection services. Go back and take a look at that contract and see if it's clear, if there was a mistake in the monitoring detection services, whether it's clear who's to blame and how much liability that third party has. Go check that. Because I can tell you, we pull those contracts and they're terribly in favor of the vendor, and you will not be pleased.
So we'll pause there to see if anybody has any questions. Nope. Question?
Anyway, you were talking about that sometimes IT can just feed the board and the legal team fluff, and it's not quite sure whether they're just waving their magic hand over it or not. One of the things that I found that I'd be interested in your take on is we talk about ransomware. If you talk to IT, they may say, hey, that's really all just about countering with backups and off-site backups, and if you do that, then ransomware doesn't matter because you just turn it back on. So how does your fluff detector go off if I say something like that?
Well, the first response is that the major Fortune companies that we have represented in these cases, their online backups were destroyed. The threat actors know how to get to them and they destroy them. Offline backups, what I would say to that is if you have offline backups, and we've lived this pain many times, people are not appropriately thinking through how long it takes to recover, even if you have offline backups, even if you have immutable online backups. So even if you do have immutable online backups, which by the way is not as commonplace as you might think, it takes a lot longer to recover. So then when you couple the pressure of being out of business and stolen data being threatened to publish, this is why you see a lot of companies make payments.
Yeah, and the fact that we're seeing a trend towards extortion only. So if your company's most sensitive intellectual property is stolen, but you can still recover it, that's still a major loss to the organization.
I mean, we're dealing with a major crisis every week, and these aren't small mom and pop companies either. So it's not, I mean, we're not here to just sit here to tell you like you should be all freaking out right now, but we are telling you that you need to do more as lawyers, because every one of our clients, we have long-term clients that we get and do business with them because we help them through a crisis and then we help them build their security program. It should be the other way around.
When you talk about it takes a long time to get back up and running, even if you've got good backup, long time, is that days, weeks?
Weeks.
Months?
Weeks.
At least weeks, and that's if you have good critical sort of, if you have your systems prioritized by criticality really well, you're talking weeks. Even if you get the decryptor tool from the threat actor and pay a whole bunch of money to get it, it's still taking weeks. And there's sort of a tale that happens in all of these cases, that there will be certain services that you spin up. But when you think about one of the biggest challenges in ransomware cases, and you guys probably have seen this in the news, you see these headlines and you're like, that would never happen to us, or we would never say that. One of the things that is really hard in ransomware cases is communications. Communications to your customer, because everybody hits you at once. All your customers and clients and consumers, and everybody wants to know a whole bunch of stuff that you're not prepared to answer. So preparing on, we've had clients spend tons of money and time just preparing for comms, having go bags, separate systems that are prepared literally to spin up with phones. I mean, literally thinking about out-of-band communications capabilities and being ready to go and conduct business. Because you can't have pure redundancy. That doesn't work. Right. You have to think things, the more you think about this in advance, the better.
And the continuity plans that we typically see are based upon what would expect if we had a regional type of an incident that impacted certain parts of the business, whether it's an earthquake or whether it's a major, power outage, things like that. Preparing from a business continuity standpoint for an enterprise-wide IT issue, not many companies are doing it, and it really takes a lot of thought leadership within the company to position the company to be out for days and weeks. It takes a lot of work. So, the worst case scenario really is a week measured in weeks, not days.
Any other questions? Yeah, thank you.
Thanks, everyone.